Broadcast is now starting. All attendees are in listen-only mode.
Welcome to today's webinar, everyone. I'm Anna Hobson and I'll be moderating today. The presentation will be about an hour long. If you have any questions, please submit them in the question box and Bridget and Emily will get to them throughout the webinar. If you need more COVID-19 resources or would like to watch more webinars, please go to hrsimple.com/events. That's up on the screen. Emily did do a webinar for us back in February on employee performance documentation, and I'd highly recommend checking that out. You can find that under our recorded webinars section. HR Simple provides federal and state-specific manuals. We help make employment law easy. Our books are written by top labor attorneys like Bridget, one of our presenters today. She is the author of the Model Policies and Forms for Iowa Employers book, which is up on the screen, and we are offering 40% off all purchases for attending the webinar. You can use the coupon COVIDWebinar40 at hrsimple.com/shop. Bridget is a leading litigator whose practice focuses on employment law. Bridget regularly drafts and litigates restrictive covenants, including non-competition and non-solicitation agreements. She represents employers of all sizes in various state and federal courts and administrative agencies. She drafts and counsels employers in human resources policies and procedures, employment discrimination, FMLA, ADA, wage and hour, NLRA issues, and union avoidance. She also assists employers with employment-related immigration issues. Emily defends employers against allegations of sex discrimination, age discrimination, race discrimination, FMLA and ADA violations, wrongful termination and violation of public policy, and tortious interference. To help employers maintain a productive workplace and avoid litigation, Emily partners with clients to provide supervisor and manager training, investigate internal discrimination complaints, provide reasonable accommodations to disabled employees, and navigate issues surrounding family and medical leave. And on that note, I'm going to go ahead and pass it over to Emily so we can get started.
Okay, Anna, I just hit the button to show my screen. Will you let me know when it's ready to go, and then I'll turn it over to Bridget.
It's full screen. It looks perfect.
Okay.
Well, good afternoon. I think it's afternoon for most of us. Some of you west may still be before the noon hour. This is Bridget Penick. Emily Pontius is my partner here in the Des Moines office of Fredrikson and Byron. We are going to tag team this topic a little bit, and I think focus there is the word team. We have a very robust labor and employment group, and we consider these presentations to be a team effort. For those of you handling all of this on your own in an office or team of one, I salute and applaud you. This is certainly uncharted territory that we are all trying to navigate through. Listening to Anna's description of our bios, it looks like we're going to have to add some more acronyms, FFCRA and maybe CARES Act to those bios soon, as will all of you. We are here to talk about the evolving workplace during the COVID-19 pandemic. Hearing Anna's reference to Emily's presentation in February, gosh, that seems like ages ago, but here we are moving forward and trying to maintain all of the employment practices as well as keeping our employees and the public safe. In the last couple months, obviously workplaces have experienced dramatic, sometimes sudden changes due to COVID. As we go through the topics today, you'll see the kind of 4 categories bullet pointed on your screen now. We aim to cover as much as possible in the little over an hour that we have with you. We also have received a large number of questions in advance from attendees that we have interspersed with the presentation. we know that those are the things you really want to hear about. And so we'll try to focus on those and insert the ones that we've received already as they seem to logically fit in the presentation. And we'll save the last 10 or 15 minutes perhaps to address any questions that come up through the chat. We'll gauge that as we go. So I will begin with the first topic, modifying the workplace to minimize risk and adhere to the CDC and state-specific guidelines. You will see the next slide here goes right to CDC guidance. That is because it would be impractical to go through all 50 states' rapidly changing guidelines. I'm sure that you have resources available in your state, and for those of you with locations across the country, lucky you have many opportunities to read and digest and try to assimilate your plan as much as you can into one cohesive plan. I've been advising recently a client with employees in 4 states, and they're just all across the board. Minnesota has very detailed information available with actually a helpful template for creating a preparedness plan, whereas Iowa, where we are, doesn't have near the same requirements or tools for implementation. And the same, Missouri has a focus on contact tracing that the employer needs to be aware of. So my first and foremost piece of advice here is consult your state Department of Public Health, or like Iowa has the comprehensive coronavirus website. Different governors handle things differently with proclamations. Mayors have been implementing their own requirements. So we understand that this is a lot of information. We are going to try to keep things as general as we can so that we're not alienating any of our attendees. And we will use the CDC and the federal guidance as our fallback guideline here. So turning to the CDC guidance, what you see on the screen is a site that I have bookmarked and I frequent, if not every day, then at least a couple of times a week. This is the CDC's page for businesses and workplaces, and I've just included a screenshot of the top portion. You can see down the left-hand side there are several tabs that drill down into industry specific, whether you're in the critical infrastructure fields, manufacturing, there's a guidance for office buildings. And so when I assist HR folks or owners, whoever's responsible for managing this, and it really is the whole management team, this is where I often go second after I go to the state-specific guidance. I highly recommend you consult this often. I print out and highlight it, but then I get a little nervous and check back because sometimes updates happen without a lot of publicity about them. So make sure you're frequenting those pages. The next resource that I would suggest you use is something that you may not think of top of mind when thinking about coronavirus, is OSHA. There were some questions that were submitted about OSHA, and I want you all to be aware. Again, here's a screenshot of the guidance. It's a 35-page guidance to prepare workplaces for COVID-19. Again, this is like the third resource after your state and your CDC guidance. I turn to OSHA. If you don't have a preparedness plan created, or if you want to put meat on the bones of your plan, this is a very good resource to flesh out some of the specific steps. Going to a preparedness and response plan, that's the catch-all phrase. Some states actually require you to put a plan in writing that addresses preparedness and response to COVID in the workplace. Others don't. If you do draft a plan, and I think regardless of what your state requires, it's helpful to have a game plan. It should be specific to each workplace. Obviously, what works in your office may not work in your manufacturing facility or for your truck drivers who transport goods. So to the extent you have employees in different types of workplaces, you're understandably and naturally going to have some variances in what your requirements are. The CDC interim guidance for businesses breaks down workplace controls into these 3 categories: engineering, administrative, and PPE. We know PPE stands for personal protective equipment. So I'll touch a bit on each of those right now. The engineering, those are, as you might expect, physical changes. How can you physically change your workspace to best avoid COVID-19 exposure and transmission? We have done assessments within our own office to, how far apart are workstations? Can we separate them? Can we have stations with hand sanitizer and wipes throughout the facility? Are there doors that maybe we could remove or leave open to help air circulate, or to avoid touching, right? Some of those high contact surfaces, doorknobs, light switches, can you easily switch to automatic lights so you don't have people flipping switches? Similarly with water in sinks. I think most places have shut down drinking fountains to avoid spread in those areas. So you need to think about engineering as the physical changes to workplaces. And again, that there's no one size that fits all. There are some guidances on those changes on the CDC website. Ventilation is something that, maybe a more costly endeavor, but making sure vents are open for one thing. If you have windows that can be open, consider, this is not the norm, but we're not in a normal time right now. Maybe have those windows open. The administrative category is really what we do, advise on drafting policies, procedures, protocols, trying to maintain consistency and have information documented so that someone could step in your shoes if you're the one managing, or that supervisors are certain about what to do. The first ranges identifying sick workers and ensuring they stay home. And I'll turn to health screening in a few minutes to dive a little bit deeper into that. There are workplace cleaning and disinfecting protocols. We have a lot of posters up around our office, for example, reminding people of hygiene, wash your hands, sneeze into a tissue or your elbow, things like that. How do you handle deliveries or customers or visitors? Are you going to treat them all similarly? Will you have them require screening? Will you require face coverings? There's no federal mandate on a lot of these ideas. So the templates that are provided are really to get you thinking about what will work best in your facility or your workplace, and also remain compliant with any state or local measures that are applicable. Then a confirmed or suspected COVID-19 response plan. I'll hit on that again near the end of my segment here. What is the current guidance for how to deal with exposure? And just a bit on the personal protective equipment. Again, if you watch the news, there's been some conflicting and almost politicized commentary about face coverings. There are some states now that are requiring face coverings, but again, there is no federal mandate. And so whether you do or you don't is really up to you on the first level, and then whether you have a state or local mandate that applies. And I'm talking outside the healthcare context. Obviously, if someone is a healthcare provider, there's a whole separate section of personal protective equipment that needs to be considered and implemented. So we'll turn to the health screening. The first question we often get is, do we have to do health screening? And again, the answer is no. Generally, there's no across-the-board federal requirement. It may vary by industry or state to state. South Dakota, for example, has a template questionnaire for employees, so that's very helpful. Our firm has decided we have a pop-up of each time you log in that has, the symptoms. Are you experiencing any symptoms? Have you been exposed? The checklist that the CDC puts out there. And we also have a visitor log just so that we can track, you know, in the unlikely, hopefully, or unfortunate event of an exposure, we would know, have an idea of who may need to be contacted. If you screen, who should be screened? Well, you have to keep in mind that all the other state and federal laws still remain in effect, even though we're dealing with this pandemic. So you can't single out, for example, just the pregnant employees or the people over a certain age or only people with certain health conditions. You need to have a across-the-board screening process. If someone, however, requires an accommodation and for the screening, and you know, there's some dialogue on the EEOC's website about that. If certain screening measures are prohibited by a health condition. I can't think of one off the bat, but they're, you know, it would be like any other reasonable accommodation request. You engage in an interactive process and say, okay, maybe you can't stand up to have your temperature taken, but you know, we'll come to you, for example. Just consider those accommodations that may be requested, and you treat them like any other reasonable accommodation request. What types of screening? Again, it's really all across the board. I mean, it can be from a on your honor system, you know, employees are expected to do these 2 or 3 checks, you know, check your temperature, scan for any symptoms, think about whether, you know, you have been exposed to anybody and do those daily before they report to work, or you can have someone on site. If, you know, at home, the pro and the con is the honor system is just that. And some employees feel the pressure or incentive or the need to get to work and earn that income. And so they may not be forthcoming. Whereas you could maybe catch some of those symptoms if you were doing the screening on site. Keep in mind or consider pay practices. You know, it's a bit up in the air still, but we take the position that this is an integral part of work, and employees probably should be compensated for the time that is involved in screening. Think of it as, you know, donning protective equipment, things like that. If you do screening on site, it needs to be as, you know, confidential as possible. You see the commercials, or at least I do, of the employee standing at the front door, scanning all the coworkers' foreheads, coming in, "Hi, Jim, how are you today? Look good, go on through." That is a bit facetious to me. It makes me nervous because you don't want broadcast to whoever's standing by what the results of the screening will be. So if there is a discrete location, that would be the advised place to do that. Back to the type of testing or the type of screening, the CDC has, again, identified symptoms and factors for any written questionnaire. So if that's your approach, I would suggest you take a look at that. The EEOC has come out and said that temperature taking is expressly permitted during a pandemic. Otherwise, it could, you know, this is a gray area of, is it a medical inquiry that you'd have to analyze under the ADA, but the EEOC has said temperature taking is permitted. If you have the resources to do COVID-19 testing, that is permitted, but antibody testing may not be required before an employee can return to work. So again, you may not think about the EEOC as a resource you would go to during a pandemic planning process, but it is addressing things that might be related to ADA issues. So take a look at the EEOC guidance on pandemics. That would be the 4th federal resource that I would refer you to. And then we can go to the next screen here. You want to have your system in place and communicate it obviously prior to screening. And so I assume that many of you are already conducting this and have already done so. But you know, you want, if changes need to be made, you know, developments are happening all the time in this arena, communicate them and implement. Keep up to date on the guidances, and keep the FFCRA, we'll hit that a little bit later, and other rules in mind. For example, what happens when there's, if someone has a temperature over 100.4, you send them home. Is this a scenario where they could be eligible for FFCRA paid sick leave? And what to do with results. This was one of the questions that was posited to us in advance. There was a question about screening employees. The question was, is it required to save employees' daily emails to the questionnaires? I'm not certain what those emails consist of or what information is within it. As you know, under various laws, generally the rule of thumb is keeping health records for 3 years. You don't have to keep temperature checks necessarily. New York, for example, would prohibit keeping records of temperature checks as under its prohibition on keeping records of employee health data. So check your state law first. OSHA, as you'll see on the screen, has now changed its course. On a May 26th guidance, OSHA, employers who are covered under OSHA who are not exempt from the OSHA requirements may have to track COVID-19 cases. If a case is confirmed by CDC guidelines, the case is determined to be work-related, which means the work environment either caused or contributed to the COVID-19 case or significantly aggravated someone's pre-existing injury or illness. And the case involves one of the various recording criteria in OSHA regs, so death, certain days away from work, or medical treatment. So again, this is a shift. If you read early guidance on OSHA, they were staying away from this, and now it's becoming an issue. So that leads to another question from the audience. How can you debate about the trace if an employee got the virus at work or somewhere else? Well, that's a really tough question. The general, common sense is it's almost impossible to know where an individual contracted the virus. We have had in Iowa here certain outbreaks in meatpacking plants, for example, nursing homes. And so when there is a hot spot or an outbreak like that, it seems a little more likely than not that the spread occurred at least to some of the employees at work. But I would refer you to that OSHA guidance because it goes through a checklist, sort of a decision tree on how you can determine whether, or how OSHA will determine whether this was a workplace incident. There are also states like Iowa just passed in the last couple of weeks limited liability laws for businesses who take reasonable measures to protect against COVID. So that is something to check as well, to say, well, are we protected by law? Let's go through the next couple slides here so we can switch over to Emily here. The workplace engineering we already talked about. I just wanted to put a few more topics here on the screen for you. And Emily may talk on adjusting some of the policies, like travel, for example, when we get to that section. But these are things to think about if you haven't already, or if you have remote workforce is just starting to get back. What are your social spaces? Are they going to be available for employees? What about elevators? Some buildings say a minimum or maximum of one person per elevator. That's going to take time for people to get to work. So maybe we want to stagger schedules to accommodate that transportation. And then again, the masks or other PPE, you can make that decision on a site-by-site basis if that makes sense. And then we'll go to the next two slides, talk about, well, training. Yeah, we'll hit training. Obviously, people who are implementing your policies need to be trained. Minnesota actually requires training across the board for all employees on what the preparedness response plan is and how employees should be handling situations, like when they should stay home, how to social distance, some of the common sense things you may think. And so how are you going to do that training if people are remotely? You're going to do a Zoom meeting perhaps. You certainly, many are cringing at the idea of having 100 people gathered in a conference room to go through this. So it seems like the Zoom or electronic training seems to be the most popular way to handle that. So the next two slides are, what do we do when we do have a confirmed or suspected case? What I've included here on this slide is really the current, as of this morning anyway, excerpt from the CDC. In a workplace, if an employee reports a positive test, the good news is generally you do not need to shut down the entire facility. If it's been less than 7 days since the sick employee was in the facility, let's say they show up today and test positive, the guidance is to shut down the particular area where that sick person has worked, let it sit for about 24 hours to try to, dissipate any infection, and then disinfect. If the person's been remote or out not feeling well, and then finally confirm a positive test and it's been 7 days or more, you don't really have to do anything different for the cleaning procedure. And for informing coworkers, you don't have to make a company-wide announcement. The guidance is to really inform employees who may have been exposed, but you need to do your best to maintain confidentiality. Sometimes it's obvious, sometimes the employees self-disclose, but the employer shouldn't be the one who says, oh yeah, Jane on the 3rd floor has tested positive for COVID-19. The communication would be, we're sorry to tell you that you may have been exposed to COVID-19 in the office, and so the current guideline is that those potential exposures stay home for 14 days, and telework if possible. So there's a whole separate decision tree that you get to if someone is quarantining and then they become symptomatic or they test positive, and that can change the course of time for remaining outside the workplace. So following the CDC quarantine and isolation and then the return to work guidelines are very important, and I have to just work through those on a case-by-case basis when I hear of individuals who've been quarantined or tested positive. And that can range from, you've heard the 72 hours after symptom onset to 10 days after symptoms first appear. That tends to be the most routine guidance to use. The last slide here in this section is external reporting obligations. There is no federal obligation to report cases to the CDC or to report them to your state agencies. Certain state departments of public health may require reporting to them, and I often recommend that employers do report that. And if employees are tested, that case is going to be, I think all states are tracing those tests and tabulating that data. So the employer doesn't have an additional responsibility to report that. There is some healthcare provider rule that requires mandatory reporting. And then I mentioned when there's an outbreak, I think the Iowa Department of Public Health wants to know if 10% or more of your employees have become infected so that they can go in and do some surveillance testing and other things. But that's it, really. There's no obligation. There's a question, is there an obligation to release a notice to the public? There isn't. Each state has different contact tracing procedures. I had a client yesterday call me who has the facility for developmentally disabled individuals, and a lifeguard at their pool tested positive. And so they fortunately had, they could identify the lifeguard worked these shifts. They have the tracking system of every, member card that was swiped, and they are presenting a communication to those members saying, you visited the pool at a time where a lifeguard worked, or, they don't say lifeguard, where there may have been an exposure. And so again, it will vary case by case. So I'm going to flip it over here to Emily now.
All right. Thank you so much, Bridget. I'm going to start off talking about layoffs, furloughs, recalls, reduced hours, and unemployment. Lots of good stuff to talk about there. So um, some employers have already been through this process with their employees during this pandemic, but others were able to take advantage of, for example, those payroll protection program loans and may only now be facing the possibility of furloughs and layoffs. In advising employers through this, we've learned a lot. And one of the things we've learned is that people do not always agree about what they mean when they use the words layoff and furlough. So since we don't have completely clear definitions understood by everyone, what you can do is be clear about what you intend and what your expectations are. So if the goal is for employees to retain their health insurance, you should use the language required by the health insurance carrier to avoid, for example, triggering COBRA when you intend someone to come back to work. If employees will not be working and will not be paid, you have to make it clear whether this pause or break is intended to be temporary or permanent. And if the break is temporary, clarify whether you expect employees to remain on that group health plan and what they need to do to make that happen. Do they have to continue to try to pay their portion of the premium? Or do you as the employer intend to pick that up during the time off work? And if the break is temporary, what kind of notice can employees expect when you're ready for them to come back? Will it be an hour before the start of the workday, or will you give them a few days? It's really good to let people know what to expect for all of this to go as smoothly as possible. And finally, how are the employer and employee going to communicate during this time? For example, will they still have access to the workplace email? Maybe they'll still have a workplace cell phone issued by the company. Are they going to get a letter, a call? Good time to update that contact information to make sure that you know how to reach your employees when they're not coming in every day. And then I want to say too that, a lot of employers have brought up the WARN Act. The 6-month mark is really key here. And so if you put people on furloughs or layoffs in mid-March, you still have a little bit of time, but it is creeping up on us. So I would say just make sure that you're keeping track of that, so that if we need to provide some WARN Act notifications, that you're looking both at the federal requirements and at your individual state requirements. And I want to talk about employer decision making. I have spoken with so many clients who want to do whatever they can to take care of their employees right now, and that is very admirable. But you have to keep in mind all of the potential things that could happen. What are all the contingencies that could occur during this time? And then just play by all the rules, because if you play by the rules, you'll be protected in the event of a contingency, we hope. So the rules are for unemployment, for the Paycheck Protection Program, even though those keep changing, I know, for the Family's First Leave, for furloughs and layoffs, and for FMLA leave. So if an employer lays off or furloughs some employees, the employer really can't decide who to furlough based on who might have young children at home or who might be more vulnerable to the effects of COVID-19, certainly not based on age. You also can't make that decision based on knowing that someone is really, really fearful of getting COVID-19, if that's a, kind of a general fear. So the safest way to make decisions about who to send home is to base the decision first on job function and then on reverse seniority. So for example, as an employer, if you have 3 people who work in the front office as appointment schedulers, and you only need 2 right now, the safest route is to furlough the person last hired. That person may be eligible for unemployment, and right now, that may mean that the person that you're furloughing may end up getting paid more than when he or she was at work. And they might get paid more than the appointment schedulers who are more senior, who are still coming to work every day. And then let's say another appointment scheduler with more tenure becomes eligible for and goes on leave under the Family's First Act. Then the employer can recall that earlier laid off or furloughed employee. Then that person needs to come back to work, even if they don't want to, because they're getting more on unemployment. But the employee who goes on leave under the Families First Act only gets the paid leave available under the FFCRA because there was work available for that person when they went on leave. So they're not eligible for unemployment because they went on that Families First Act leave. So these are really hard decisions. And as we can see just from that brief example, every action has another reaction that follows from it. You know, you could have 3 people off work, one on the Families First, one on getting, you know, regular PTO, and one person getting unemployment. And they're all getting paid differently. And it may not seem fair, but you're following the rules. And I think these decisions are the hardest for those of you who are at smaller organizations because you know your employees. You know their underlying health conditions, whether you want to or not. You may know their family economics, and they have a lot of questions. They want to know, will there be layoffs? Can I just be on unemployment since my kids aren't at school or at daycare? What happens if my husband loses his job? And really what you have to do is be able to say, we're following all the rules and we're trying to do our best to treat you well. Lots of questions these days about reducing hours too, and as an alternative to layoffs or furloughs. So employees with reduced hours are always entitled to unemployment benefits once they drop below a certain threshold. But employees who are reduced as little as 20% to 50% can receive unemployment benefits if the employer participates in a short-time compensation program. And this is a federal program, but states have to apply to be a part of it. So this program can be beneficial, but there are some administrative hoops. You have to keep careful records, you have to manage your work so that you're uniformly reducing hours. You know, in the end, it's not something that I have advised for a lot of employers because it's hard to plan ahead right now. But if there's a large population of employees who have the same job function and you can kind of uniformly reduce hours, it could be a good option. And you know, this kind of leads into one of the questions that we got before the presentation. And that question was, what is the best way to pay salaried employees who are coming back to work but with reduced hours or reduced days? So if they're 80% of their normal schedule. Well, you know, it always depends. There's always you know, different things that go into play for different employees, but even if the employee is an at-will salaried employee, you can reduce their salary. The Department of Labor says that a prospective reduction will not cause a loss of the employee's exempt status if the reduction is due to a business or economic slowdown and the deduction is not made based on day-to-day or week-to-week determinations of operating requirements. So this would be more of a, you know, for the foreseeable future, we're going to have you at 80%. It needs to reflect long-term business needs. So if you're doing salary reductions, you also need to ensure that that the reduction doesn't bring the employee below the FLSA minimum salary threshold. And that's currently $684 a week. But for a lot of salaried employees, you'd have a little bit of leeway there and you can choose to reduce salary. And I'm going to make a plug here for our question of the day series on the Fredrikson and Byron website. A lot of the content that we're providing today and a lot of the answers to questions are things that we've put on our question of the day. It's a great resource, and if you go read those questions, you'll see that I just provided one of the answers that one of my colleagues provided a while back. So it's been a great internal resource as well, and really an example of the value of the team that we have here. Okay, so recalling. When things start to open up and you're recalling employees, you know, for some employers, this means everyone comes back right away, but many are trying to do this in a phased way, either because of operational concerns or what they actually need, or just because they want to just do this gradually and see what happens. You know, just as when you're deciding who to furlough or lay off, the order of recalling employees is important. Again, it's job function and seniority. The first factor is job function. What job function do you need back in the workplace? And then seniority. You got to recall the people who have been there the longest first. Some employers like to ask for volunteers and take other factors into consideration. That could work. However, my concern is that things are very unpredictable right now. So what if you recall first a more junior employee thinking that, well, you know, we'll give the more senior employee a few more weeks on with these rich unemployment benefits. We'll bring them back in a couple weeks, but then you find out the business has really contracted and months pass and unemployment benefits run out, and that temporary furlough that the more senior employee is on actually becomes permanent. Well, then what do you do? I think there's just a risk for employers who don't follow the strict criteria of job function and seniority, even if you departed from those guidelines for the best of reasons. So as employees return to work, keep in mind they may need to request leave for childcare reasons. Recalls are also going to trigger employee concerns related to the pandemic that employers have not dealt with during furloughs. So it could be that someone who was furloughed early on has been able to take care of their children. They've been able to accommodate any health conditions or disabilities that have come up. Now that they're recalled, you're going to have to deal with those individual situations, perhaps need for the Families First Act leave. And as we're seeing in Texas, Florida, Arizona, other states, we cannot just decide it's time for things to be normal again. I've heard the return to normal described as the hammer and the dance. And we need to be prepared for the possibility that employees are going to come back. We'll start on the road back to normal, and then we're going to get hit by the hammer of another COVID surge, and we have to retrench again. So as much as we hate to think about it, this could happen repeatedly until we have a vaccine or some other development that minimizes the impact of the virus. And this really underlines the best advice that I can give right now as far as relations with your employees, and that is don't make promises you can't keep. It's very possible that people will come back and that there'll be another round of furloughs or layoffs over time again. Unemployment benefits, there's been a lot of developments, and these are very state by state. And this is another case of underlining the point that it's so important to not make promises or rely on any promises about what unemployment benefits someone may receive if they are laid off or furloughed, or if they stay home to self-isolate or to care for children. Eligibility is determined by the state unemployment agency, not by you, not by me, not by the employee. Employers cannot control what an employee may include in their application for benefits that might, you know, cause it to go sideways and not be what you would think it would be. So if they're asking, if you have an employee who is asking about unemployment benefits, the best thing you can do is refer employees to the website for the appropriate state agency. In some states, they're not charging employers for the COVID-related claims and not requiring fact-finding interviews, but it really is a state-by-state thing. So the best thing you can do is either maintain in close contact with your counsel who is licensed in your state, if you don't internally have the resources to stay up on those things. Okay, and I think we're back to Bridget.
Great. Well, what next? We have workforce back, if any of them left, and we realize that you are all across the board in that respect. What are some options for managing leave or requests going forward? Keep in mind that we'll talk about the FFCRA first. It was effective April 1, and it's set to expire December 31st unless Congress acts to extend it. There's been some discussion about that, but nothing substantive that I have seen. So just a refresher, you all should have your notices posted. It covers employers with fewer than 500 employees. It does include employers with fewer than 50 employees who are not covered by traditional FMLA, but there is the small business exemption that employers of that size could seek, and we'll talk about that in a moment. You count all employees, full-time, part-time, temporary employees on leave, and counting that number. Employers who hover right around that 500 mark have to be extra vigilant here. We dealt with this a little bit more early on when some of the shutdowns were being implemented, and that, you know, if you had 500 or more employees on May 1st, so you weren't covered, then you furloughed a group of employees and you dip below the 500 mark, then your FFCRA coverage may kick in. And furlough, Emily talked about the furlough versus layoff distinction. That really doesn't matter here. If they are not working, they would not count. So the relevant date that you'd look at is when the leave is to be taken. So it's not a one snapshot in time, it's sort of a rolling analysis, much like your regular FMLA if you have a rolling 12-month period. And then if you are not familiar yet, there are 6 possible reasons that an employee may be eligible for. It's emergency paid sick leave or emergency family medical leave. There is this model notice that is on the Department of Labor website that should be posted in all work sites. So the six categories are if the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19, and those individuals would be eligible for 2 weeks of paid sick leave at full pay, but that is capped at $511 per day. The second reason is if the employee is advised by a healthcare provider to self-quarantine due to COVID-19, and again, those employees would be entitled to 2 weeks of paid sick leave at full pay with a cap of $511 per day. The third reason is if an employee is experiencing COVID-19 symptoms and is seeking a medical diagnosis, same 2 weeks of full pay with the $511 cap. And similarly, the fourth reason is employees who are caring for an individual subject to an order to quarantine or to advice by a healthcare provider to self-quarantine. Those employees would get 2 weeks of paid sick leave at full pay. The fifth reason is the distinction reason here for employees caring for children whose school or place of care is closed or a child care provider is unavailable due to COVID-19. Those individuals are entitled to both 2 weeks of paid sick leave at 2/3 pay and then 10 weeks of emergency family medical leave. It's the Family Medical Leave Extension Act. And that 2/3 pay is capped at $200 per day. The sixth reason we haven't had reason to or occasion to consider yet, it's basically a catch-all that if the Department of Health and Human Services determines there's something else out there, a substantially similar condition that employees are experiencing symptoms of, then they would be entitled to the leave for the same reasons. Again, to date, the agency has not specified any such conditions, but we've heard all kinds of rumblings from another potential swine flu out there to other potential pandemics. So we hope those don't arise, but there is a provision in the statute that would allow for that. Record keeping is very important here because you can get reimbursed as the employer for the leave that you provide. There was a question from one of you, what is exactly required for documentation? There's actually a whole section in the regulations that go through for each type of leave. We have, if you want to reach out, we do have a model leave request form, and you may have those from other HR or legal resources as well. And that we drafted that to identify the specific documentation and information you need in order to then get that reimbursement of that leave pay. So the other question we got in advance on this topic is, can an employer require an employee who was around someone who is COVID-19 positive to test and stay off work and pay them under the FFCRA. So two different issues I see there. One is an employee who was exposed to COVID-19 can be required to stay home for 14 days. You can make that decision as an employer. You do not have to pay them. The phrase being around someone is a little vague. Right now, the CDC defines close contact as within 6 feet of someone with the symptoms or a positive test, and that's a duration of 15 minutes or more. So walking past someone in the hallway necessarily doesn't constitute exposure, but a little longer prolonged contact would. The FFCRA is if the employee, it's a leave request, and so you can't really force that upon employees, but the scenario that was raised in the question, it doesn't really fall under one of the 6 reasons exposure. Now, if the employee were seeking a medical diagnosis, if they chose to do that, then certainly that would fall under it. So there are there are a few different ways to approach that question, but absolutely the employer can require an employee who's been exposed to stay home, much like earlier on when people were traveling to areas that were considered hot spots, you could require them to stay at home. You know, always consider work from home if that is an option. The additional question that I'm going to address here from an attendee asked, under the FFCRA, is caring for an individual in quarantine, isolation, or related to COVID, can that person be a parent in another state? So if you look, this is my plug for yet another federal agency. The Department of Labor has a website that has questions and answers. It's dol.gov/agencies/WHD/pandemic/FFCRA hyphen questions. And question 64 explains that in the regulations also addressed in section 826.20A5 that an employee cannot take paid sick leave to care for any individual. It must be an immediate family member or someone who regularly resides in your home, or someone you have a relationship with that creates an expectation that the employee would be the one to care for that person. So unpacking that, a parent is an immediate family member. The regulations do not address where the parent is located. So it's not conjunctive, it is must be an immediate family member or someone who regularly resides in your home. So I would say given that scenario, if the employee is needed to go take care of, you know, a mother in Arizona, then the employee would be entitled to the leave. We can move on to the next screen here. I just wanted to highlight there is an exemption for employees who are healthcare providers and emergency responders. I helped several healthcare entities make that determination kind of upfront in April when this was implemented. Because the regulations require a judicious interpretation, meaning that you narrowly apply the exemption is how we read it, we encourage this to be a case-by-case determination. Some healthcare facilities have made a blanket across the board, we will not be providing leave, and that seems to have been okay. I just get concerned because of this seemingly potentially conflicting requirement and vague requirement that you apply that exemption judiciously. Healthcare provider is defined very, very broadly. Anyone employed at any doctor's office, hospital, healthcare center, clinic, post-secondary educational institution offering healthcare instruction, medical school, local health department or agency, nursing facility, retirement facility, nursing home, home healthcare, any facility that performs lab or medical testing, pharmacy, or any similar institution. So again, that's quite broad. And so that exemption, you know, the rationale there is we need healthcare providers to care for people who are sick. And so there are different requirements for those frontline workers, and we very much appreciate the work that you all do in that arena. There is, I mentioned the small business exemption. That is for employers with fewer than 50 employees. It's only available for that unavailability of school or childcare reason, number 5 for paid sick leave and extended family medical leave. And there's quite a bit of documentation. You know, you have to have an official, an authorized officer provide a determination that the leave would result in the business's expenses and financial obligations to exceed business revenues, or that the absence of the employee would entail substantial risk to the financial health of the organization, or that there aren't sufficient workers who would be willing and available to perform the work if the leave had been granted. So if you have sought exemption under that, you need to keep those records for 4 years, and you still need to post the FFCRA notice. So again, this is not an exemption from the 2 weeks of paid sick leave when someone is sick or caring for someone sick who is sick or quarantining. So that's a bit on that. I do want to, I included the next slide to show that the agencies are still very active. This is a more recent development on the Department of Labor's website. It's a tool for employees, and you'll see on the bottom, the employer tool is coming soon. So these resources are out there for the employees to just, you know, self-check. Am I eligible for this FFCRA leave? And the whole goal of this is to keep the sick people isolated so that we can minimize spread. So stay tuned for that employer tool. The last slide on the FFCRA is about reimbursement. I am not a tax lawyer, nor is Emily, but this is a question that employers ask, and so we've gathered this information from our tax lawyers. You can claim your reimbursement on your quarterly Form 941 tax returns. Again, as I mentioned, there's a whole list of the different types of information you need depending on the type of paid sick leave. And so look, I've noted the regulations are at 826.100, and they just go section by section on the type of leave and the type of documentation that you need to have. And again, these records are to be kept for 4 years. That note about topping off, you will have the ability, if an employee's earnings has available vacation or PTO or sick leave as may be applicable, and you decide to top off that over the cap that's in place, just keep in mind that you're not going to get reimbursed by the federal government for that, the topping off. That would just be as if you're paying your normal payout of sick leave or PTO, etc. So we wanted to talk about 2 additional avenues for leave here. One is what I like to call regular FMLA. FMLA leave may be available for COVID-19 reasons. You have to keep in mind the reasons that someone may take FMLA leave. So the employee has to be covered and be eligible. Remember, this would be, like for employers who have 500 or more employees, and so the employees are entitled to FFCRA leave, or maybe for healthcare workers who've been exempted, or someone who's actually had COVID-19 or is caring for a family member and they run out of their 2 weeks of FFCRA leave. Reminder that FMLA is only available to covered and eligible employees who have worked 1,250 hours over the last 12 months and have been employed for 12 months, and who also work at a site with 50 or more employees within a 75-mile radius. So one question an attendee asked was, will employees be eligible for FMLA if they were not working during the stay-at-home order? We have a rolling look-back period. So they still need to meet the requirements. Employed 12 months, though, remember, that's not consecutive months. So it's their entire tenure of employment to be employed. And then they had to have actually worked 1,250 hours within the last month. So if someone had been on furlough, they may still count as being employed, but those hours don't count towards the 1,250. And just note that the FFCRA does not increase the usual or the annual limit on 12 weeks of FMLA. So it's combined a maximum of 12 weeks other than the military caregiver leave, which allows you 26 weeks. There is here yet another website from the DOL on pandemics. It actually talks about the flu, but the heading has been updated to refer to coronavirus. So I assume the DOL is intending those rules to be analogous. Like if there were a flu pandemic outbreak, they're just treating the same rationale and provisions to coronavirus. Now, FMLA may not be taken for these 3 reasons. You cannot request FMLA leave if you just want to avoid getting COVID-19. We have so many employees who say they have underlying conditions and their doctor won't let them work, and my employers want to help and say, can we give them FMLA leave? And I have to think, well, what will they be able to get the certification from their healthcare provider that they have a serious health condition that prohibits them from working? Sometimes they may, if the doctor says that a certain condition is keeping the employee from working at the moment, but often they can't. The next area, you can't take FMLA leave to protect high-risk family members. There may be other leave options, but not FMLA leave. And FMLA leave is also not available to care for your healthy children. The extended FMLA leave that was implemented under the FFCRA is, but regular FMLA leave is not. The last leave, the ADA leave that we will think about, ADA reasonable accommodations. Someone who is in that higher risk category, I'm sure you've all dealt with those questions of how do we accommodate? Is leave an option? It may not be a traditional leave. It may be a special situation where you grant unpaid leave. You can do that. You need to be as consistent as you can be and not single out one condition for the other, but you would go through that reasonable accommodation analysis and engage in the interactive process. Teleworking has been an option for many of us, and that seems to be a really reasonable way. Keep in mind we're all a little bit nervous that now that we've all made the switch to teleworking, it's going to be very difficult next year if an employee requests to work from home as an accommodation for a health condition for us to say, no, that's an undue hardship. Well, is it? Because we were able to do it for 4 months and counting in 2020. Think about also mental impairments have been on the rise. You've heard about increased depression, anxiety, PTSD. Now, those are conditions that may require accommodations as well. And then you can still deny ADA accommodations due to undue hardships, and the EEOC has actually included 2 questions on their June 11th guidance, which you'll see there on the page, that talk about specific COVID-19 related undue hardships. Let's say you're in a precarious financial situation already now because of COVID-19, and granting this key person additional time off would significantly harm the business. I mean, these are very fact-specific scenarios, but the EEOC is acknowledging that that situation may be unique at this point. And the last slide here on the ADA is, again, a family member's health condition does not entitle an employee to leave under the Americans with Disabilities Act. That's also addressed in the June 11th guidance on the link that was on the prior page. I mean, the EEOC stated the ADA does not require that an employer accommodate an employee without a disability based upon the disability-related needs of a family member. So just keep that in mind because those requests are coming in. Again, you may still provide flexibility and other accommodations, but it wouldn't be an ADA accommodation. And the final warning, again, is do not engage in disparate treatment based on protected EEO bases. So you can't pick and choose which conditions you're going to accommodate or not. You can make a case-by-case decision based on the job, the responsibilities, the function, and the individualized situation there. All right, I am done with that.
Okay, so we're going to zip through some information about policies and handbooks here. Workplace safety, workplace rules, screening, masking, social distancing, all things that were not necessarily part of our lives 5 months ago. You have to provide a safe workplace, and that means following the guidance from all of those agencies, federal agencies that Bridget mentioned throughout her presentation. And this may mean adding some rules to your handbook about workplace conduct and disciplining employees who fail or refuse to follow the rules to maintain distance, wear masks, otherwise maintain a safe workplace. So I have been answering questions from many employers who are concerned that employees will disregard or refuse to follow safety and health guidelines related to COVID-19. We hear in the news that people are treating masks as a personal choice, even though the masks are there to protect others as much as to protect themselves. There's a lot of interesting arguments and analogies out there to promote mask wearing. Mine is a stop sign. It's not a personal choice to stop your car at a stop sign. If you fail to do it, you endanger yourself and you endanger others on the road who are following the rules. So if your policy is that you're going to require masks in the workplace or in certain areas of the workplace, you have to treat it like any other workplace rule that is there for health and safety. So one of the questions that we got from an attendee was, do you have any guidance for addressing employees who refuse to wear a face covering per requirement by the employer? Well, to begin with, you absolutely have to do that diligence to find out if there's a good reason for not obeying the rule. So for example, the employee may have a disability or health condition that prompted the refusal, and you can explore alternatives. So perhaps they'd be willing to wear a face shield. Could the employee perform his or her duties in an area of the workplace that does not require proximity to other people? A private office, an empty room, a cubicle surrounded by plexiglass or other barriers. But if the employee has no reason other than a personal choice to violate the rules of your workplace, that's insubordinate conduct. And in this case, it puts others at risk. My suggestion would be to send the employee home without pay and implement your no-call, no-show rules if subsequent absences occur because the employee fails to come to work with a mask or appears at work without the required face covering. Another question that came up is, what are some tips that you can provide for dealing with essential employees that have developed bad work habits due to the reduced hours? So that's an interesting question, and I'm not sure I totally understand it, but I interpret it as you've had essential employees who have been coming to work all the way through this crisis, and conduct has kind of slipped. Maybe different dress standards, casual hours. I think this is an opportunity to treat it as a new beginning, just like when you move to a new office space or you have a new supervisor or a new owner. It's an opportunity for a reset. And this can be paired with a gigantic thank you to those essential employees who kept things going. I would suggest framing it as the essential employees setting an example for everyone who may have trouble transitioning back to work after they've been furloughed or working from home. And, it has to be said, this is a good time to evaluate things like workplace stress and flexible hours, and consider whether some of those quote unquote bad work habits might really increase employees' enjoyment of the workplace, and maybe some of those bad habits, maybe we should keep a few of them. I know that's a crazy idea. And then leave policies. Those FFCRA obligations are going to continue until December 31st. Then you'll be back to your normal leave policies. I think as people adjust to the workplace during and after the pandemic, we can expect employees to be a lot less tolerant of any symptoms of illness at work. Employers have broad leeway to tell an employee to go home if they're coughing, if they're exhibiting other symptoms, and we really want employees to stay home when they are sick. This may not be right for your workplace, but maybe you want to consider expanding who's eligible for paid leave due to illness. and maybe being more lenient with employees who have school cancellations and childcare issues because of closures and illness. You know, and I realize this is controversial. I'm not suggesting that you give everybody another 2 weeks of PTO or anything like that, or sick leave. And I certainly would not suggest saying that this is going to be the policy from here on out, but maybe another 6 months of being a little bit more lenient about when it's paid and when it's unpaid. A question was asked, if an employee is out sick with a cold, stomach virus, etc., what would be the protocol for returning to work? Well, you can rely on your current policies. If this is not a COVID-related illness, you normally would not require a doctor's note to return or a fitness for duty protocol to return to work, so you shouldn't require it now. You would really just revert back to what you would normally do if someone had a routine illness like cold or stomach virus. And I want to address, just in the few moments we have left here, the remote work issue. We're all learning a lot right now about remote work. Some companies are going to go fully remote. Either way, you need to make sure that you make some policy modifications and communicate if you're going to have some changes. So is this temporary or permanent? Is it voluntary or required? And as Bridget mentioned, this is going to affect the analysis for accommodations that involve working from home. And I want to address one last question that we got prior to the presentation. Do you recommend telecommuting agreements with employees as they transition to permanent remote workers? You know, I think that can be a great idea. You can absolutely do an individual telecommuting agreement for employees who are going to do that. You can also include a policy in your handbook to cover the basics of telecommuting across the board, and then only have those separate agreements when there's an employee who for some reason needs something a little bit different. I would recommend that the basic policy contain language stating that the employer may revoke remote work arrangements at any time, and how much notice you'd be required to provide. And this could be due to project needs, client needs, and preferences of supervisors. Those policies should also include expectations about availability. Do you expect that a remote worker is going to be available if you call anytime during the workday? What are you going to require that they have a dedicated workspace for them to be able to work remotely? Are you willing to provide resources for them to set that up? And also, what about childcare? If someone's working remotely and they have young children, do you expect that they will have full-time childcare? And make sure that employees know the limitations on who can allow working from home. I have had situations where a supervisor, without any authority from the organization to do so, told a new employee that she could work from home. So she relied on that and moved outside of what I would consider a reasonable commuting area. So at first she had an apartment locally so that, you know, during the week she was living near work, she could come to work. But after the supervisor said, oh, you can work from home, no big deal, now she's in another state. So when that supervisor left, a new one comes in, he wants to kind of rein everything in and bring people back to work. This person has an issue. So just a few things to keep in mind. It looks like we have some limited time here. Bridget, are there any questions that wait, I'm the only one that can see the chat. I'm sorry.
No, I can see it.
Oh, okay, okay.
I'll answer a couple. Yeah, I can address a couple here. One question was, must be from when I was talking about FFCRA reimbursements. It says, could get reimbursed, what may cause you not to? That was perhaps a bit flippant by me. You have to dot your I's and cross your T's. The regulations permit private sector, and I think that next question also addresses this issue. Private sector employers are supposed to be able to get reimbursed 100% of dollar for dollar up to those caps. You have to do your homework and submit the request, and it should be in the form of a tax credit. So I have not seen any expansion to that to state and local governments to answer your next question. But again, stay tuned. There have been talks about tweaking these provisions going forward. And then there was one other, the 14-day quarantine question. This last question, number 6, if your state only recommends but does not require a 14-day quarantine, would the employer have to pay FFCRA during the quarantine? And then Emily maybe can address would the employee be eligible for unemployment? But the language in the regulations about a quarantine or isolation order is pretty broad. I would say based on that question, the answer would be yes. And here's why. Under the definition section 826.10 says for purposes of the EPSLA, Emergency Paid Sick Leave Act, a quarantine or isolation order includes quarantine, isolation, containment, shelter in place, or stay-at-home orders. This also includes, I skipped a line there, when the state or local government has advised categories of citizens to shelter in place or quarantine. And so I would interpret the recommendation as advice, and that's what we had in Iowa. There was never really a mandate, but we treated that as falling within the requirement to provide that paid leave. Look at.
Okay, and I can try to address one more question here in our, we're officially out of time, but I'll see if I can slip another one in. It says, for employees who have been successfully teleworking since the pandemic began, what do you recommend for returning on site? Well, first of all, what do you want to happen? I mean, if you're assuming you're the employer, you have employees who have been very successful, very productive. You know, it really depends on what the boss wants here. Is it important from a policy standpoint for you to have everybody back at work or not? And if it's not, I think a wise choice is to say, if you're working from home and you're successful and you want to continue, let's keep doing that. But put a reevaluation timeline on it. Like, let's do it for another 3 months, because this is still, we're still in a danger area of the pandemic, because the fewer people at work, the more safer those in the workplace will be. So I think that wraps up our time. So I will stop showing my screen and turn it back over to Anna.
Awesome. That was a great presentation. If you did want to follow along again, I am going to post it on hrsimple.com/events. And I just wanted to thank Emily and Bridget once again for doing this. This has been awesome. We got a ton of questions answered. And if you do have any other questions, please don't hesitate to email me. It's right up on the screen, anna@hrsimple.com, and I'll be happy to forward those along. And then I just wanted to remind everyone, you can use the coupon code COVIDwebinar40 to get 40% off any hrsimple.com purchase. And thanks for tuning in, everyone. I hope you have a wonderful day. Stay healthy out there.
Thank you.